I guess there was just Will and Lynn. That's the only two that I have.
Ready? Right, we are on the record, and this is October 9th, 2023 at a little after 8 a.m. It's 8:02. For the North Dakota Industrial Commission case number 30329 on a motion of the commission to consider amendments to the general rules and regulations for the conservation of crude oil and natural gas codified as Title 43 North Dakota Administrative Code. Copies of the proposed rules are available either online or I don't know if we have some available here, getting them. A sign-up sheet is also on the table. Please, in front of the microphone there, please sign up if you want to present testimony or comments today. After these announcements, I will be calling on people in order on the sign-up sheet to come up and speak. This hearing, as well as the other hearings which will be held by the commission this week, today and tomorrow, will be streamed live, and I believe streaming live, and can be listened to via the Department of Mineral Resources Oil and Gas Division website. The Industrial Commission is required to adopt administrative rules in accordance with NDCC Chapter 28-32, and the administrative rules hearing is held pursuant to NDCC Section 28-32-11. The purpose of this hearing is to ensure the public has an opportunity to provide their comments and submit data, views, or arguments before administrative rules are adopted. It is important to the administrative rules process that the public's comments are received and considered. If anyone believes that their ability to participate in this hearing is hampered by a disability of any kind, please let me know so that I may arrange the means for you to fully participate in this process. Please remember that this is an administrative rules hearing and not a legislative or court hearing. The purpose of this hearing is to get input from the public, especially those who have not yet had a chance to be heard concerning these rules, or those who have not or will not have an opportunity to submit written comments. This is not a question and answer session. The purpose of this hearing is not to pose questions to the commission staff about the proposed rules, but an opportunity for the commission to receive input, like I said. So please try not to repeat testimony of others, but rather refer to previous testimony you agree or disagree with instead. But I ask that you start your testimony by stating your name, address, and the organization you are representing, if any, and to make sure we understand the comments you're providing, commission staff may ask you questions following your testimony. Mr. Ron Ness, would you like to begin with your testimony today?
Good morning.
Good morning.
My name is Ron Ness, President of the North Dakota Petroleum Council. I'm here today to just make a few introductory comments, and Brady Pelton, the Vice President of the North Dakota Petroleum Council, will provide our detailed comments, which have been assembled by a large committee of our membership over the past several weeks, delving through the various rules. So I thought first today, I thought it was just important recognizing where we're at. I think the world events of the weekend are startling, and frankly, I don't know what that's going to do to oil this morning, but I am quite certain that there will be an impact. And I think sometimes we look at rules and we think these rules before you today are relatively simplistic. We've been through rules after rules after rules over time, but really the importance of the rules today, number one for me, is the vision set forth by the 2023 legislative session. And when I think back and I look at how the Bakken transpired and the impact that it's had on our state, and tens and thousands of North Dakotans and people have relocated back to North Dakota, come home, provided a great future for us and our children and their children. But the future potentially could be beyond the Bakken. And the 2023 legislature looked at that with House Bill 1272. They recognize that we're probably never going to see hundreds of billions of dollars potentially invested back into well bores. And the importance of House Bill 1272, and recognizing that That infrastructure, like a downtown anywhere across North Dakota, can be revitalized and it can be put back to use. And we've seen that historically throughout North Dakota's oil patch. But this is unique. The Bakken was something that was world news. We were and still are the swing producer in the world. Our 1.2 million barrels of oil today matters. It will matter greatly today and throughout the rest of this conflict in Israel and potentially beyond that. So I think it's very visionary of the legislature to think about there's much more oil. We had produced 1 billion barrels of oil prior to the Bakken. But most importantly, this agency, the Industrial Commission, the legislature, starting putting pieces in place for the Bakken well before we had any concept that it was going to be the Bakken. We just made the right policies. We made the right policies to ensure that now we have 3-mile laterals, 2-mile laterals, and a very uniform system. Moving to 3-mile laterals, we've reduced the environmental footprint. Look at what we've done with gas capture, the rules that the Industrial Commission put in place, but allowed the industry to build out almost unprecedented levels of gas capture today, which I believe prior to that, we still probably had the cleanest barrel of oil in the world today. We're looking at every producer's looking at emission-reducing technologies. We've seen the investment of funds into the reclamation of wells across the state. So we got a lot of concerns about some of the rhetoric taking place about across North Dakota, and I, for one, certainly don't want to go back to where we were in the early 1980s, a state in which we grew our young people up to deport them across this country and to other places for jobs and opportunities, and then as grandparents we had to follow them there. So I think your work is very important, but let's think about since we discovered the Bakken in early 2007 or late 2006, we're going to approach 5 billion barrels of oil. Took us virtually 60 plus years to produce the first 1 billion barrels of oil in North Dakota, but that's what's created the buzz. But it's good policies. The governor's advancing another version of the Red Tape Reduction Act. I think that's an important process of this, what you've done with North Star. We have a very competitive oil and gas climate across this country, and I continue to see the Permian attract more and more capital in New Mexico and Texas, and we have to continue with a smart, thought-out, planned regulatory regime. But I do believe the provisions of House Bill 1272 set us up for that next phase of going back into the Mission Canyon. And if done right, you can actually advance the plugging of wells that don't have the wellbore integrity. We're gonna talk about some things in our rules proposals today, our comments that look at these wells regularly. But this is not just a pro-industry bill. This is a pro-environment bill. It also ensures that small operators down the road, large operators have a tendency to look at older wells or declining wells as a liability. This actually puts them in a position where they can move it over to the asset side of their balance sheet for a while and preserve that rather than just plug it and move on. Because I'm afraid that's what we will see as large operators have many assets across the United States. They don't look at fields the way typically the folks after the boom come through. So we want these fields to be in place, and we also want to go and look into areas, older fields, and critically areas that not in the heart of the Bakken, but we know what it means in West Hope and Max Bass. And as we see some activity up there now, I get the calls from the people up there excited about activity in their communities. And of course, 100 to 200,000 mineral owners in our state have a great importance to us. So I will turn over our official comments to Brady, but I think your work is very important here, but we got to look ahead to the future. Thank you.
Thank you. Mr. Brady Pelton, could you state your name, address, and organization? We know the organization you're representing, but please restate it for the record.
Certainly. Well, good morning. My name, for the record, is Brady Pelton. I serve as the Vice President and General Counsel of the North Dakota Petroleum Council. Our address is 100 West Broadway Avenue, Suite 200. You'll find the address and full information on our organization's logistics on the cover letter that I've just submitted. Proud to represent the comments that have been generated on behalf of our over 565 member organizations within the North Dakota Petroleum Council. Really, as a background, to formulate the comments on behalf of the industry, we assembled a small technical advisory group that really dug into the proposed rules and how they might affect or could potentially affect industry operations. With your permission, I'd like to go through them and feel free either during or at the end to ask any questions that I might be able to help answer. All right, beginning with section 43020301, subsection 27, the creation of an inactive pipeline definition. NDPC questions the relevance of the proposed language defining inactive pipeline. The full notice of intent to adopt and amend administrative rules published in conjunction with the rule proposal states the proposed amendments, quote, acknowledge inactive pipeline is referred to in North Dakota Administrative Code section 43-02-03-55, but was not defined, end quote. According to that section of the Administrative Code, quote, if an underground gathering pipeline is inactive for 7 years, the commission may require the pipeline to be properly abandoned, end quote. The language of the proposed definitions ties an inactive pipeline to one that has been removed from service for more than 1 year. If the commission believes a definition of inactive pipeline is indeed necessary, we recommend clarifying the definition by including what it means for a pipeline to be, quote, removed from service, end quote. Moving on to section 14.2 related to oil and gas metering systems. NDPC recognizes the intent of the commission to refocus regulations from all meters to meter proving equipment used to test the accuracy of oil meters in this proposed rule amendment. Industry appreciates this regulatory change, which appears to better align the regulatory goal of ensuring metering system accuracy with the more appropriate object, in this case, meter proving equipment. NDPC also appreciates the proposal to remove paper filing requirements for allocation meter installation and use approval forms and requests for variances from requirements of this section. The North Star system adequately allows for online submittal, and NDPC commends the Commission in its goal to modernize the regulatory process through use of new technology. Moving on to Section 15 related to bond and transfer of wells. NDPC notes that the proposed language in paragraph 5.c appears to introduce additional parameters under which a new operator of a well shall be subject to a new bond. Specifically, the scope of what may be included in, quote, appurtenance to such a well is not clearly defined and may be interpreted by some to include more than what is directly associated with the transfer well in question. An indirectly associated appurtenance may in fact belong entirely to other operators and should not be the responsibility of a well transferee to cover in the transferee's bond. NDPC requests a clearer definition of appurtenance such that its scope is more properly tailored. NDPC also requests clarity on how, quote, inadequacy of reclamation status, end quote, as included in the proposed language is to be defined and evaluated. Moving on to subsection 10 in section 15, dealing with enhanced oil recovery potential well bonds. NDPC recognizes the importance of financial assurance mechanisms in any kind of industrial development. This is especially true of facilities of a particular age. The 68th Legislative Assembly granted the Commission the authority to approve a well for enhanced oil recovery potential status when unanimously enacted House Bill 1272 earlier this year. The objective of the legislation was clear, and that is to preserve viable well bores otherwise subject to plugging and abandonment requirements and allow for enhanced oil recovery or EOR techniques to advance to the commercialization level, further expanding North Dakota's oil and gas production potential. NDPC is comfortable accepting requirements for bonds on such wells, particularly those that will undergo EOR techniques later in time. However, NDPC also requests language be added in the proposed rule amendment, making it clear that the bond requirements of the new proposed subsection replace the bond requirements throughout this section of the administrative code and are not in addition to them. Further, we view the annual review of bonds amounts on wells under EOR potential status to be excessive and an unnecessary use of time and resources. As an alternative, we request consideration of instead stating that each such bond may be subject to an annual review. NDPC would also welcome a required review after a longer, more appropriate period of time, such as after a 2 or 3 year period. So regular intervals. Moving on to section 16, application for permit to drill and recomplete. We appreciate the perceived intent of the Commission to alleviate some inefficiencies in the well site preparation and well drilling permit application process with the proposed rule changes to this section. However, verbal approval for well site preparation may already be given by the Director in extenuating circumstances under the existing language. NDPC questions whether the listing of examples of what extenuating circumstances include in this section is indeed necessary. If the Commission determines that these examples are necessary, we would request consideration of adding weather events to the list. Having the ability to construct a well site before a permit to drill is approved is incredibly valuable to the operator seeking to develop a well location prior to when ground temperatures are below freezing. And flexibility in such circumstances allows for more rapid development and more timely development. NDPC supports the proposed language at the end of this section, allowing the Director to extend a permit to drill and a permit to recomplete or drill horizontally for up to 1 year upon request. This option provides additional flexibility and avoids the administrative burdens on both operators and the Department of Mineral Resources associated with having to reapply for such a permit after it would otherwise have expired. Moving on to section 16.3 related to recovery of a risk penalty. Two subsections in this section that we have raised issue with. The first one is in subsection 1, paragraph B. NDPC has concerns that removing the requirement that an election that an election to participate in well expenses be in writing may create unnecessary uncertainty in the risk penalty recovery process. Elections to participate, when codified in writing, help to establish a reliable record and eliminate opportunities for inconsistent recollections of whether an election to participate in the well expense has been given. The same concept applies to subsection 2, paragraph B. Within this section, we again have concerns that removing the requirement that an election to participate in unit expenses be in writing, and that this may create unnecessary uncertainty in the risk penalty recovery process. Moving on to section 21, related to casing, tubing, and cementing requirements. While NDPC appreciates the Commission's perceived attempt to provide clarity in the requirements of this section, we believe the proposed rule change that would require cementing of surface casing only, quote, while the drilling rig is on the well, unquote, is a step in the wrong direction. Modern drilling techniques and well control mitigation measures have allowed the industry to be in full compliance of surface casing cement rules without a rig being on the well where cementing is occurring. Mud circulation can be verified prior to walking the rig to the next well on the well site, allowing for cementing to be done while the rig is, quote, offline. Requiring a drilling rig to be on a well undergoing surface casing cementing is cumbersome and will preclude offline cementing after the departure of a rig, should the Director not approve this as, quote, another method per the proposed rule amendment. Offline cementing offers a significant means of increasing efficiencies and improving proper sequencing of drilling activities. NDPC therefore requests the Commission consider seriously the benefits from offline cementing and reconsider this element of the proposed rule change. Moving on to section 28, related to safety regulations. NDPC appreciates the Commission's proposal to include an oil processing vessel placement allowance within the North Dakota Administrative Code. In accordance with the Center for the Chemical Process Safety Guidance for Facility Siting and Layout, NDPC proposes the Commission consider the oil processing vessel placement distance be set at 50 feet, or 15.25 meters. Additionally, NDPC requests additional clarity on how the measurement from oil processing vessel to a producing well or oil tank should be taken. NDPC proposes the measurement be defined as the horizontal distance from closest edge to closest edge. For the treater to vessel distance, this would be from vessel edge to flame arrestor or burner air inlet edge. And this is just to have a consistent method of measuring that distance that we request to be at 50 feet. Mr. Sagsby, and I just add at this point that, in addition to this proposed rule change, I believe several of our individual members will be submitting independent commentary reflecting on their individual perspectives of each of the proposals. So
Okay.
We'll look at that later. Moving on to section 29 and subsection 4, which is on page 29 of the proposed rules. NDPC believes current permanent above-ground pipeline marker placement and maintenance practices are currently adequate to protect public health and safety at this time. NDPC members currently place line markers based on line of sight, landowner requirements, and/or locations that clearly necessitate markers for safety purposes. Markers that are color-coded with product or contact information are routinely utilized at road, fence, and tree line crossings. The language proposed in this new subsection does not provide additional information as to the required frequency of markers along linear rights-of-way, nor does it clarify specific areas where such markers should be placed. This addition is ambiguous and may require the placement of more or less line markers based on the director's discretion. If the Commission determines the addition of this requirement is necessary and not simply an expansion of regulatory authority for expansion's sake, NDPC requested additional clarity on what the phrase, quote, discretion of the director when necessary to protect public health and safety, end quote, may mean. Implementing this proposed rule could impact landowner relations, project costs, and project schedules. If insufficient line markers are being properly or permanently placed in the field, NDPC suggests that justification be shown to adjust those requirements directly instead of creating a great deal of uncertainty. This comment mirrors, for the record, that related to proposed rule amendments in 430203 29.1-16. Moving on to the rule proposal related to pipeline reclamation in section 29.1, subsection 5. In paragraph C of this subsection, NDPC raises concerns with the proposed rule amendments related to pipeline reclamation. Right-of-way reclamation within the proposed 180 calendar days is not a reasonable time frame. As an example, if construction completes on a pipeline on October 1 and snowfall starts around this day, the proposed rule amendment would allow only until March 29th of the next year to complete rights-of-way reclamation. In this scenario, the ground may likely remain covered with snow and/or remain frozen by the time reclamation is to be completed. In another example, consider pipeline reclamation within the exterior boundaries of the Mandan, Hidatsa, and Arikara Nation. Here, approximately 1 month is needed to bid and award an on-reservation tribal contractor for reseeding a given project area. About 1 month is needed to complete the reclamation work here. These factors, added to other potential delays like weather conditions and contractor availability, underscore the difficulty in properly completing right-of-way reclamation within 180 calendar days as proposed. Further, complete reclamation of a right-of-way includes steps like reseeding, touching up, redressing, and other steps required to get pipeline rights-of-way as closely as practicable to original condition as per the code. These steps, when followed to the requirements of the law, take significantly longer than 6 months. As an alternative to the time period proposed, NDPC recommends the completion period be expanded to 1 year in order to accommodate proper right-of-way reclamation processes and both the expected and unexpected complications that construction in North Dakota is known to bring. Moving on to subsection 6 of section 29.1 related to inspection. NDPC has significant concerns with the proposed rule amendment in this subsection that would both require third-party independent inspectors, quote, during all aspects of crude oil and produced water underground gathering pipeline construction, end quote, and require an arbitrary number of such inspectors during the installation process. NDPC believes the language during all aspect of construction to be incredibly broad and poorly defined. This proposal will likely have an unnecessary dramatic effect and impact on construction costs and staffing ability. There is a shortage of qualified inspection personnel in North Dakota, which creates an even larger problem if operators are staffing up to satisfy the unclear parameters of this proposal. Similarly, likely staffing and construction cost consequences exist with the proposed addition of allowing the director to require additional third-party independent inspectors. We question the necessity of effectively introducing additional uncertainty into the pipeline development process by potentially allowing an undefined number of third-party inspectors to be required during all aspects of construction. NDPC is not currently aware of crude oil or production water gathering line construction instances that would justify such a broad discretionary overreach as the one proposed. We believe current language is more than adequate, and we recommend withdrawal of the proposed changes for the Commission to remain consistent with Governor Burgum's commitment to reducing red tape in state government. NDPC member companies are competent in staffing their projects and determining the level of third-party independent inspectors necessary to adequately ensure sound and reliable pipeline installation. Moving on to subsection 8 of section 29.1, related to underground gathering pipelines as built. In paragraph L of subsection 8, we seek clarification on the application of the proposed rule amendment seeking to require the Geographical Information System, or GIS, layer of an underground gathering pipeline be within 20 feet of horizontal accuracy. We question whether this proposed rule would apply retroactively to previously built pipelines. If so, legacy pipelines will need to be resurveyed at considerable cost. Additionally, not all legacy pipelines constructed prior to the origination of Commission regulations on locatable without excavation or hydrovac. Enacting a regulation that requires a 20-foot accuracy declaration on legacy pipelines for the entirety of its GIS footprint is impractical. In subsection 16 of section 29.1, we believe that current permanent above-ground pipeline marker placement and maintenance practices are adequate to protect public health and safety at this time. NDPC members currently place line markers based on line of sight or landowner requirements. Markers that are color-coded with product and contact information are routinely utilized at road, fence, and tree line crossings. The language proposed in this new subsection does not provide additional info as the required frequency of markers along linear rights-of-way, nor does it clarify specific areas where such markers should be placed. This addition is ambiguous and may require the placement of more or less line markers based on the director's discretion. And again, just moving forward, this comment mirrors those related to the proposed rule amendments in 43020329, subsection 4. Moving on to section 55 proposed rules, starting with subsection 2. The proposed language in subsection 1 of this section extends abandonment language for oil and gas to subsurface observation wells defined by removal of monitoring equipment. However, the proposed rule amendment in subsection 2 does not extend temporarily abandoned status applicability to those wells. Given the potential long-term utility of subsurface observation wells for potential future adjacent Class 6 and other injection wells, subsurface observation wells should be eligible with similar approved requirements for temporarily abandoned status. NDPC appreciates the clarity sought to be achieved by the proposed rule amendment in the first sentences of this subsection. Finally, we have on page 52 of the proposed rules a new subsection 3 proposed, and we comment that the proposed language in this subsection creates the parameters for oil wells to be approved for enhanced oil recovery or EOR potential status. NDPC applauds the Commission for proposing this administrative rule following legislative passage of House Bill 1272 during the 2023 legislative session. As stated previously, NDPC fully supports the creation of an EOR potential well status, which will allow both legacy and unconventional wells to remain unplugged and available for EOR application into the future. The biggest benefit to the EOR potential well status proposed in this subsection is best described as preservation. This refers to preserving the wellbores that have been the subject of tremendous investment by industry, while developers await the availability of miscible fluids like carbon dioxide that will allow EOR activities to enter the commercial stage. Development of the infrastructure necessary to support the quantity of EOR fluids necessary for commercial scale EOR operations is likely to take some time. A well status providing that time for a well with EOR potential viability to remain unplugged in non-production status is critical. Industry in the state of North Dakota stand to gain a great deal if operators have wellbores available to utilize in EOR development. These benefits extend to the landowners owning the surface estate on which wells qualifying for this status are located. Preserving existing wells that have EOR techniques applied will allow an even higher production level, but without the need to construct a new well facility or drill new wells. Thus, the surface impacts of EOR development will be minimized. Despite the many positives of the well status proposal, NDPC believes some of the language proposed in this section may be too restrictive to be utilized effectively when comparing the well criteria here to that of a well on temporarily abandoned status. The well configuration criteria between temporarily abandoned well status and EOR potential well status should be the same. As the proposed rule currently reads, the EOR potential well status criteria are much more restrictive. Concerns related to wellbore integrity of wells that qualify for EOR potential well status are valid. However, NDPC believes that more frequent or periodic mechanical integrity testing may be the more appropriate regulatory requirement in ensuring wellbore integrity than restrictive qualification barriers. NDPC views the current language in the proposed rules criteria for EOR well status as constructed for injection of fluids based on the similarities compared to saltwater disposal well or other injection well criteria. Reservoir depressurization is an industry-recognized method of EOR that does not include injected fluids into the well. Therefore, we believe that this rule should not be written as if all EOR potential wells will be injecting fluid. As written, the proposed rule would restrict EOR reservoir depressurization potential of producing legacy wells that do not meet the well configuration criteria. And we have suggested language that will help, in our opinion, remediate that restrictive nature of the proposed rules as it's written. And you'll note on the fifth line from the bottom, we suggest mechanical integrity testing annually in order to ensure that the wellbore remains well constructed. And with that, Mr. Sagsveen, I'd be happy to answer any questions of the panel.
Right, does staff have any questions?
Brady, thanks for your testimony first off. I'll start with your last page, page 10, being that's just what you discussed. I want to make sure I understand what the Petroleum Council here is stating. You crossed out in red there, the wording in red, I should say. Is it essentially the Petroleum Council's definition that the director has deemed the subject well to have potential use, meaning in your thought this also to include if the wellbore integrity, the casing, so on and so forth, is capable of being used for potential use in the future?
Yes, Mr. Tabor, just to answer that question bluntly, yes. We believe that the potential of any given wellbore to eventually be used for enhanced oil recovery techniques to be applied to it should certainly be an evaluation tool that the director has in making that determination.
And then, and I have to find the page here quick, so bear with me. I believe it is on in reference to your discussion on offline cementing, are you stating that the rule change, in your opinion, would, that's on page 4, sorry, not allow for that technology in the future, or are you stating that operators are currently doing this, and by changing this rule, it would prohibit that?
Yeah, Mr. Tabor, that's the case. It seems to be, just on feedback gathered from our membership, that this technique is one that would be very beneficial, offline cementing that is, and currently it's either not being permissed or there's other restrictions in place. The feeling was within our working group that the language presented in this particular rule change proposal, that it would further restrict that and put certain parameters on. Certainly making it the norm in requiring a rig to be on site when that cementing is done, which we collectively feel like there should be a better standard, incorporating that flexibility to use offline cementing techniques when appropriate.
I'll probably have a few more, but I'll let the others go first.
Morning, Brady. I just have one comment on your 16.3, the recovery of a risk penalty. The proposed rule does not take away the requirement that it be in writing. It's just contained in a different section. It's in 16.31A, notes that it must be in writing. So we didn't repeat it further down in the rule then.
Mr. Boer, I appreciate that clarification. We'll certainly look into that and revisit that in supplementary comments as appropriate.
Okay, thank you.
Yeah.
Brady, on that 16.3 comment, I I just want to make sure I understand your concern. Your concern is that the response to the invitation has to be in writing, so that we have a clear record? Is that what?
Dr. Helms, yes, that was the concern raised by members of our working group, is that the response to the invitation to participate, i.e. the election to participate, should be in writing in order to provide a better foundation for a better paper trail, if you will.
Okay, so we'll look at that, but you want to make sure that both the invitation is sent out in writing and the response or the election to participate or not participate is in writing as well.
Yes, that's correct.
Okay.
Any additional questions?
On the pipeline marker comment, see if I can find that one. Are there, did your committee talk about specific locations where underground gathering pipeline operators are using markers, or where they are appropriate?
Just based on the feedback, Dr. Helms, that was received from our membership base, no, I guess I'll go right back to our comment. Markers that are color-coded with product and contact information are routinely utilized at road, fence, and tree line crossings. And we feel collectively that if there are other areas, specific instances where above-ground markers are necessary, that should be spelled out in the administrative code. On a broader note, we appreciate generally director discretion in the responsiveness that it brings to the regulatory authority of the commission. But it was felt that the majority of our membership felt that that was just too broad of authority, and it was undefined enough to raise concern that the costs associated that with installing those above ground markers might be problematic, and a complication to landowner relations as well, depending on where those above ground line markers might be required.
And somewhat along the same lines, on the previous comment, 29.1-6, on the third-party inspectors, we've had several situations recently where our inspectors shut down an operation for a day or a half a day because a third-party inspector was being shared between two projects and wasn't on the pipeline project at the time when something that we felt was significant was occurring. Did you all have discussions about what types of pipeline construction operations should require a third-party inspector to be present while that's going on? So, for example, pipe laying or welding or coating, or and I'm just throwing things out there. But did you discuss?
Yeah, Dr. Helms, actually, we did not discuss that in depth. I think the general feedback that we received was that the definition was just frankly too broad. Yeah. It doesn't really provide sound parameters on which these pipeline construction folks can make decisions. So a little clarity, we can certainly do some additional, have some additional discussions and generate more data for the commission to determine if this is necessary or not, including specific instances where third-party inspectors might be more necessary.
But your point is that the phrase "during all aspects of construction" is too broad, and that there are aspects when they wouldn't have to be personally there or present.
Yeah, Dr. Helms, that was the biggest concern, is that, throughout the pipeline development process, as I think this panel knows, it's very complex, and it starts well in advance with surveying work and everything related to acquiring the right-of-way. Once that is done, then we move into the preliminary construction phase, and then it's finally installed and welded, as he's mentioned, and reclaimed. So I think we will certainly take that feedback back to our group and try to develop a path that might give the commission better guidance on where these third-party inspectors might be more appropriately required.
And then on your last comment on the enhanced oil recovery potential wells, I wasn't familiar with the concept of depressurization, reservoir depressurization as an enhanced oil recovery technique. So if you could provide, and it's not listed as one of the techniques, in our tax statute or in our EOR statute. So I was wondering if you had some publications or something to point to as that being specifically what you're talking about there. Are you talking about putting additional drawdown on a residual oil zone, or are you talking about an EOR unit that's been, fully water flooded, and now we're going to shut off the water injection, but draw the pressure back down? Just what are you referring to there? Because it isn't a term that's in North Dakota statutes or rules anywhere, this depressurization concept. And just commenting, all of the Bakken EOR projects that we're observing are huff and puff, so they do inject and produce. So the wellbores are used for both. So that's what led to a lot of the rule as you see it there. But I would appreciate some information on what you mean by reservoir depressurization and how that's used as an EOR technique.
Dr. Helms, just in response to that, certainly happy to put together, more information on that. I do know that one of our member companies is exploring EOR with that reservoir depressurization. So we are strongly encouraging that member to provide comment directly to this panel, either orally in testimony or in written comment too. But we will certainly follow up on that with supplemental comments.
And on the EOR recovery potential well bond, it sounds like you're comfortable with the idea of a blanket bond covering all those wells with limits on wells that have had that potential for 12 years or more than 12 years. The concern is with the annual review.
Dr. Helms, yes, that's correct. Our members feel like required annual review might be excessive, particularly after the review is done on the initial phase, when a given well is granted EOR potential well status. We feel that is the most appropriate time to make the initial bond amount requirement, and supplementary, as we suggested, perhaps on intervals of 2 to 3 years might be more appropriate than the annual.
I see one more. 16, weather events. Can you give me a little more color on what you discussed as weather events that that could trigger the need for approval to start construction prior to having a valid APD on a well or drilling permit on a well. I guess is the concept that you've filed an APD, but it's not approved yet, and we need to get out there and build it? Is it a little more color on what you're talking about in terms of weather events?
Yeah, Dr. Helms, that's precisely the scenario that was discussed primarily in our conversations. The fact that in the APD may be awaiting approval from the department and not yet attained, and with the uncertain nature of North Dakota's climate, particularly in the winter months, having that ability to move forward with construction of a well facility would be of great advantage.
I don't want to belabor this, but the circumstance you're describing is you file an APD, it's not approved yet, and we're coming up on Halloween, and we know that the weather often turns nasty the last half of October. A sundry could be filed saying, hey, we filed an APD and we need to do construction. And maybe that would come as early as in September so that they could begin construction. Is that, am I understanding correctly kind of how you see this working?
Yes, Dr. Helms, that's precisely the types of instances that our suggestion might come into play.
Thanks.
Brady, I had one more follow-up. On 28, you referenced the Center for Chemical Processing Safety Guidance for Facility Sitting and Layout, and it states, or you state within that of 50 feet. Is there anything else that you are aware of within that guidance that needs to be done in order to be within 50 feet that they stated, or is that something you can provide so we don't have to read through all of that?
Yeah, Mr. Tabor.
I'm assuming there's some kind of maybe like a flame arrest or, some kind of safety thing maybe that they state needs to be done in order to be that close.
Yes, Mr. Tabor, I'm happy to help with that. I know that an NDPC member company will additionally be commenting on this rule specifically, and perhaps that question may be answered in that testimony. But we're certainly happy to provide that in supplemental comments as well.
Thank you.
Any additional questions? All right, hearing none. Thank you, Mr. Pelton.
Yep, thank you.
Does anyone else have any comments for our rules this morning? Does anyone else signed up on the sheet? Any of the other gentlemen in the crowd wish to make any comments this morning? So do you hold the record open or do you just close the record?
The record's open for written comments for 10 days. Yeah, okay.
All right, since there is no one else here to provide oral testimony, I'll make some closing comments and then we will close the record. Pursuant to NDCC 28-32-12, the Commission will have a written comment period during which data, reviews, or arguments concerning the proposed rules or feedback regarding today's testimony will be received by the Commission and made a part of the rulemaking record to be considered by the Commission. All comments received both today and during the written comment period will be given serious consideration by the Commission. All comments and correspondence must be submitted to the Commission prior to October 20th, 2023 by 5 p.m. and will be made part of the record for this case. All comments received prior to today's hearings will also be made a part of the record for this proceeding. Comments received after October 20, 2023 and 5 p.m. will not be included in the record. And with that, it is 8:56, and we will close the record for today's hearing in Bismarck regarding the Commission's administrative rules.